Okay, they're at the Department of Corrections, sir. Can you tell me your name, please?
Yeah, Byron G. Goodman.
Mr. Goodman? Okay. We'll go on the record in People versus Goodman. This is file number 255099. The record should reflect Mr. Goodman's present today by video from Department of Corrections. If I can have counsel put your appearances on.
Ryan Ziegler.
Thomas Seeger appearing with an on behalf of Mr. Goodman.
Thank you. Mr. Seeger, how did we want to proceed in this file this morning?
Your Honor, it's my understanding that Mr. Goodman wishes to tender a plea to one count of resisting and obstructing with no habitual offender notice.
Is that a correct statement of the offer, Mr. Ziegler?
It is, Your Honor.
Mr. Goodman, were you able to hear that?
Yeah, I'm making a plea agreement. You turn it up a little bit, that'll be all right.
Yep, we'll speak up for you. So, yeah, the plea agreement is that you would plead guilty to one count of resisting or obstructing a police officer. The second count of assault and battery would be dismissed along with the habitual offender enhancement. Is that your understanding
Yes, Your
of
Honor.
the plea agreement? Okay.
Yes, Your Honor.
Is that how you wanted? Is that how you wanted
Yes,
to
Your Honor.
proceed today? Okay.
Yes, Your
Can you
Honor.
raise your right hand? Can you raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Seeger, is this plea going to affect any kind of parole or probation status?
Arguably, Your Honor, it could be consecutive,
Okay. Because of parole status?
not because of his parole, because at the time he was on bond awaiting sentencing for a felony.
Okay.
Kate,
To your
running
knowledge,
concurrent?
Just 1 second, Mr. Goodman. To your knowledge, is he on any kind of probation or parole at this time?
He is not, Your Honor, he's lodged at the Department of Corrections and the court had sentenced him recently.
Okay. So, Mr. Goodman, the maximum possible penalty you could face for the charge of resisting or obstructing is up to 2 years and or a $2,000 fine. Do you understand that?
Yes, Your Honor.
Also, because you were on bond at the time of this offense, the court could, but does not have to sentence you to consecutive sentencing. Do you understand that?
Yes, Your Honor.
With all of that in mind, what is your plea to that charge today?
I want to plead guilty and possibly maybe get sentenced and just throw it to the into the 5 years, make it 2 years. You know, I got like 29 months to 5 already. And
Okay, all right.
if
Well,
it's all possible.
we'll talk about that in a second. But I want to go through your rights with you.
Yes, sir.
You have the right, to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty to this crime because you are actually guilty?
Yes, Your Honor.
The information I have indicates that this happened back on September 3rd of 2025. Is that the correct date?
September 3rd of 2025. Yes, Your Honor.
Okay, on that date, were you here in Kalkaska County?
Yes, Your Honor, at my place.
Did you come into contact with the deputy from Kalkaska County?
Yes, Your Honor.
Did you know that he was performing his duties as a police officer at that time?
Yes, Your Honor.
What did you do to resist or obstruct that police officer at that time?
He told me to give him my phone and I didn't, so he snatched it out of my hand.
All right, and was he ordering you to give him your phone as part of an investigation that he was conducting at that time?
He just said I can't be on the phone while I was in the cop car and told me to give it up. That was it.
Okay, all right, Mr. Ziegler, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Counselor, either of you are both of you satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Mr. Goodman, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge of resisting or obstructing. The court will accept your guilty plea. We're gonna set the sentencing hearing for a different date. In the meantime, somebody from the probation and parole is gonna do an interview with you. And then you'll have an opportunity at that time to, we'll talk about that sentencing. It sounds like what you're requesting to have the sentences run together. Is that right?
Yes, Your Honor. See, I just had one of those pre-sentence investigations like 3 months ago for this other case. Is it necessary? You gotta do that? Can't you just like do it today? So I ain't gotta go all the way up there? Cause that's a long trip.
Well, yeah, we can do it by video. You don't have to, if you'd rather do it by video, we can do it by video.
Yes, Your Honor.
Okay, but I do need to have that report prepared for my information because this is a different circumstance and a different charge. And other than what we said here today, I don't know anything about what happened and I need to have some more information to be able to determine what an appropriate sentence is, okay?
Oh, okay, but what's the maximum be? You mean be consecutive instead of concurrent? Is that what you're
Right,
saying?
consecutive is back to back, concurrent is at
Yeah.
the same time.
Yeah, yeah. All right. I
Okay,
just
so
thought
you'll be
maybe-
notified, we'll do that sentencing hearing by video like we're doing today, all right?
All right, I'm just trying to get on and get to a level here. I'm still stuck at RNGC. I hope this court stuff ain't holding me back from getting to a regular level.
Okay.
You know,
All right, thank you. That's all for this hearing today. The
All
court's
right,
gonna
thank you.
disconnect. All right, they're at Wexford County, sir. Can you tell me your name, please?
Michael Griffith.
Mr. Griffith, okay. The court calls People versus Michael Griffith. That's file number 255101. The record should reflect Mr. Griffith's present today by video from Wexford County. Mr. Seeger, how did we want to proceed on this file today?
Your Honor, at this time, we would ask that the matter be set for trial. And if you gave us one final jury status conference somewhere in advance of trial, that may be helpful, but at this time, he intends on proceeding to trial.
Okay. All right, Mr. Ziegler, how much time do the people need to be prepared to go forward with trial in this case?
I would say at least 60 days, Your Honor.
Okay, if we set this for 90 days, is that enough time?
Yes, Your Honor.
Mr. Seeger, is that enough time for you?
Agree, Your Honor.
And Mr. Ziegler, how many days of trial do you think we'll need?
I would say at least 3 days, Your Honor. I'm probably gonna have somewhere between 12 to 15 witnesses. Without doing more digging.
Okay, Mr. Seeger,
I think, yeah, 3 days is probably appropriate, Your Honor.
3 days. Okay, so we'll set this for a 3-day jury trial at about 90 days out. The court will set it for a final status conference on the motion day immediately prior to trial. And that will be the plea cutoff. So Mr. Griffith, to the extent that there are any new or different plea offers, or you wish to discuss that further with your attorney, that final status conference prior to your trial date would be the last date to enter into any kind of plea agreement. Mr. Ziegler, are the people anticipating any kind of motions?
At least I'll be filing a 404B notice, Your Honor. I don't anticipate any motions per se.
Okay, Mr. Seeger.
Yeah, I was still contemplating some potential motions, but they would probably most likely be motions in limine.
Okay, so any motions or objections to 404B notices would need to be filed and heard no later than the date of that final status conference. Mr. Ziegler, any other dates I can address for you for scheduling in this file?
No, Your Honor.
Mr. Seeger? Mr. Griffith, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Okay, all right, thank you. That's all for this hearing today. You'll be provided, Mr. Griffith, with notices of the trial dates as well as the date of that final status conference. And the court's going to disconnect at this time. All right, People versus Darnell Ross.
Ready, Your Honor.
This is file number 255094. The record should reflect Mr. Ross is present here in the courtroom today. If I could have counsel put your appearances on in this case.
Ryan Ziegler.
Thomas Seeger appearing with Mr. Ross.
And Mr. Seeger, can you tell me the status of this file this morning?
Your Honor, an offer has been extended. However, at this time, Mr. Ross wishes to proceed to trial. So I just asked that the matter be set for trial and that you perhaps give us one final statement conference and ask that date.
Okay, Mr. Ross, is that correct?
Yes, sir.
And Mr. Ziegler, how much time do you need to be ready for trial in this matter?
I can be ready within the next 60 days, Your Honor.
Mr. Seeger?
That's fine, Your Honor.
Okay. And Mr. Ziegler, how many days of trial?
I think this would be a one-day trial, Your Honor.
Mr. Seeger?
Agree, Your Honor.
I think based on my schedule, it's probably going to be a 90-day duration interval. So the court's going to set this for a one-day jury trial at about 90 days. We will set them for a final status conference on the motion day immediately prior to trial. That'll be the motion cutoff. And Mr. Ross, there'll be one more hearing before your trial date. To the extent that you did want to consider any plea offers, that would be the last day to enter into a plea agreement, okay?
Yes, sir.
Mr. Ziegler, anything else we need to address for scheduling on behalf of the people?
Your Honor, would there be a motion cut off as well?
Correct.
I know, Your Honor.
Mr. Seeger.
Nothing further, Your Honor.
Okay, so Mr. Ross, we'll send you notice of your trial date as well as that last status conference. It's important between now and then that you stay in touch with Mr. Seeger so that you can help him be ready to proceed to trial when that's scheduled, okay?
Yes, sir.
Do you have any questions about how we're going to proceed?
No, sir.
Okay, thank you. That's all for today.
Any day.
People versus Stephanie Clay, file number 255083. All right, the record should reflect Ms. Clay is present here in the courtroom today. If I can have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Thomas Seeger appearing with behalf of Mr.
All right, this is the date and time set for sentencing in this matter. Ms. Clay, have you had an opportunity to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes, sir.
Okay. Mr. Seeger, are there any additions, deletions, or corrections?
Your Honor, there are only a couple small corrections, and they're not particularly meaningful, but on the face page, it says Attorney Kyle Travis, or at least the version that I have. And then in the body of the report, Your Honor, under the evaluation and plan, in the first paragraph, it also references Mr. Travis.
Okay, we'll make those corrections. Any other changes?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, sir.
Mr. Ziegler, do the people have any additions, deletions, or corrections or challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I would largely adopt the recommendations contained in the report. This is Ms. Clay's first felony offense. I think 7411 makes good sense in this case. Give her an opportunity to demonstrate that she can reform her behavior. It's in line with the recommendation in the report. I think it's appropriate. I'd ask the court to adopt it.
Thank you. Mr. Seeger?
And Your Honor, I would likewise ask the court to consider granting her the benefit of 7411. Clearly, this is a situation where it's a felony. It's a situation where she can walk out without having a felony. She has every reason to successfully complete probation. She has had some run-ins with the law. However, I think that she has come to a point in her life where she wants to change, whether or not she'll be able to do that. Hopefully she'll be able to demonstrate that during the course of her probation. I do know that she had made some statements relative to her knowledge of the drugs in the vehicle, but I think that it's somewhat misconstrued. She did know that they were there, and so she's not disputing that in any way. It's, I think that there was a period of time where she was making some choices based on her personal circumstance, where maybe she wasn't thinking entirely clearly on where things were and weren't particularly remembered. But be that as it may, Your Honor, I think that she's a good candidate for probation. She indicated that she wants to have an opportunity to have 7411, and she's hopeful that she'll get through her probation successfully.
All right, thank you. Ms. Clay, anything that you wanted to say today? Okay. All right, I did read through the report, so I'm familiar with what happened in this case. I'm familiar with your background and your circumstances based on the information in that report as well. I do think the recommendation is appropriate. I think probation with 7411, which would give you the opportunity to have this come off your record, which is a huge benefit to you, is appropriate to give you that opportunity. I am going to hold some jail time in abeyance. If you do successfully complete your probation, then you would never have to serve that jail time. But if you do violate your probation, because I'm holding it in abeyance, then I can impose any or all of that jail time immediately without a hearing, without anything.
Okay, so that means I don't have to go to jail now, but if I violate, then I would?
Yes,
Okay.
exactly. So I want to give you the opportunity to avoid going to jail. And, you know, through probation, you're going to have some resources available to you to help you get treatment, other things that you may need. So I hope that you take advantage of that and that you ask for that help from your probation officer. And like I said, if you successfully complete your probation, then under 7411, this conviction would not be a public record. And you wouldn't have to serve that jail. The other flip side of that coin is if you don't follow your probation, if you don't ask for that help and take advantage of that help, then you're going to have to come back and do jail time. Okay. So
Your
the
Honor.
court is going to, yeah.
Sorry to interrupt. I didn't prepare this report, but I just went and looked at some documents. And if you refer to number 1 of 6, the 2017 marijuana, it looks like she was already given the opportunity at 7411 and it was revoked. So I don't think she's eligible.
Okay, well, I'm gonna, as part of the sentence, I'm gonna ask that whoever the supervising agent is to double check that. If she's eligible, then I'm gonna make it 7411. If she's not, you know, there's nothing I can do about that.
Okay, yep, I do have the court documents showing that it was revoked in 2000. She was discharged unsuccessfully on 8/28 of 17.
Okay, all right, so it sounds like you're not eligible for 7411.
Your Honor, I guess to that way, in as much as it was a knowing, intelligent plea, and I'm not trying to slow things down because clearly we're here for sentencing, but the intent was to give her the benefit of 7411. Sometimes if a person is not eligible for 7411, the prosecuting attorney will amend the manner in which they plead. And so I don't know if Mr. Ziegler would reconsider things if you gave us another month to come back to it.
Mr. Ziegler, do you have, I don't remember verbatim what was said on the record at the plea hearing in terms of the 7411, whether that was part of the plea or whether you just weren't objecting to it.
It was part of the plea. Your
It
Honor.
was,
Yes.
okay. All right, so that changes things then, Ms. Clay. That would give you the opportunity to withdraw a plea that you made here, because part of the deal when you entered that plea was that you would get 7411. Sometimes we don't know until we do this pre-sentence investigation and figure out exactly what your prior convictions are, whether you're eligible. So because you're not eligible, you would have the right to withdraw your plea and negotiate a different plea deal or even go to trial if you wanted to. So do you want to take some time and talk to your attorney about what your options are going forward?
Yes, sir. Your Honor.
Okay. All right, so I'm going to adjourn the sentencing hearing today. I'm going to reset it as a sentencing for 30 days, Mr. Seeger, if we need to enter into a different agreement, or if she just wants to withdraw her plea and take advantage of her trial rights, then we can do that at that time.
That's fine. Thank you, Your Honor.
So Ms. Clay, just between now and that next hearing date, make sure you stay in touch with Mr. Seeger so that you know what all your options are, okay? All right, and thanks, Ms. Wagner, for bringing that up today. Okay, they're at Wexford. Can you unmute yourself, please? Sir, can you tell me your name?
Michael Smith.
All right, we'll go on the record in People versus Michael Smith. This is file number 555047. The record should reflect Mr. Smith is present today by video from Wexford County Jail. Mr. Seeger, can you tell me how we want to proceed in Mr. Smith's file today?
Your Honor, it's my understanding that people will offer Mr. Smith an opportunity to plead to one count of possession of narcotics. Dismiss the balance. Additionally, Your Honor, it's my understanding that there is another misdemeanor case which would also be dismissed, but it's not part of this information.
Okay, is that a correct statement of the plea offer, Mr. Seeger?
It is, Your Honor.
Is that the 4-year felony?
Correct.
Okay. One question before we go further, Mr. Seeger, I do see in the file here, it looks like some orders were prepared but not entered regarding competency.
Yes, Your Honor, those were withdrawn.
Okay, so as we stand here today, you don't have any concerns based on your interactions with Mr. Smith?
I do not.
Okay. All right, so Mr. Smith, the plea offer in this case is that you would plead guilty to 1 count of possession of narcotics. That's a 4-year felony. The resisting or obstructing charge would be dismissed, and the possession of methamphetamine, which is a 10-year felony, would be dismissed. Do you understand the plea agreement?
Yes,
Have you had an adequate opportunity to talk to your lawyer about that agreement?
yes,
And is that how you wanted to proceed today?
yes,
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, sir.
Thank you. You can lower your hand. Mr. Smith, are you on any kind of probation or parole?
No, sir.
Okay, and as I said, the maximum possible penalty you could face for possession of narcotics is up to 4 years. Do you understand that?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, I do. Yes,
You
sir.
understand giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They can say no, and that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said on the record here today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to this charge because you are actually guilty?
Yes, sir.
Mr. Seeger, are we taking the factual basis to the methamphetamine?
Yes, Your Honor.
Okay. So, Mr. Smith, this indicates this happened back on April 3rd of 2025. Is that the correct date?
I'm pretty sure it is. Yes, sir.
Back on that day, were you present here in Kalkaska County?
Yes, sir.
While you were here in Kalkaska County, did you have possession of some methamphetamine?
Yes, sir.
Did you know that that's what that substance was?
Yes, sir.
Did you have any legal right to have any amount of it at that time?
No, sir.
All right, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
I am, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Counsel, are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Mr. Smith, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. And you'll be brought here to Kalkaska for purposes of that hearing. In between now and then, somebody from the probation department will be in touch with you to do a pre-sentence report. Counsel, anything else we need to address on this file today?
No, Your Honor.
Mr. Seeger?
No, sir. Well, Your Honor, Mr. Smith did ask or was hoping that he could be released on bond in as much as his mother has cancer. I know that he had some problems previously showing up, which the court was concerned with, the prosecuting attorney was concerned with. Mr. Smith has addressed his mental health problem since he's been incarcerated. Speaking with him, he's doing much better, and I am quite familiar with Mr. Smith because I did handle a neglect and abuse case for him at one point in time, Your Honor, so I interacted with him on a somewhat regular basis, and he did have some pretty significant mental health problems at one point in time, and I think he still has mental health problems. It's just that he's doing a better job of addressing them currently. In any event, Your Honor, I was hopeful that he could be released on a PR bond. His mother is unable to post his bond. He's just trying to take care of her. She has cancer, and not entirely clear how well she's doing, poorly she's doing, but she indicated that she needed his help when I had spoken to her. She has reached out to me numerous times when she felt as though Michael was struggling, and so he does have good family support to that end.
Mr. Ziegler?
Your Honor, I have sympathy for Mr. Smith's situation, but given that he failed to appear back in August, a bench warrant was issued, and also that he's just accepted responsibility for a 4-year felony, I don't think that reducing his bond at this point. I would just ask the court to continue his bond until such time as we can have the sentencing.
Yeah, so Mr. Smith, I certainly sympathize with your family situation, and I'm sorry to hear that about your mother. But we have had a lot of problems getting you here in court. Before the court issued the bench warrant, there were several failures to appear prior to that. And so it's important that we bring this case to resolution. And I set a high bond in this case after the last time that you didn't appear to ensure that you would be here for future hearings. And I think it's important to leave that bond in place so that we can get things wrapped up. So the court is going to deny the request to modify the bond, and we'll set this for hearing at the court's next available date. So that's all we have for today, Mr. Smith, and the court's going to disconnect from Wexford at this time.
Can I get that PAC code?
Yes, it is 333.7403A5.
Thank you.
People versus Trepanier, this is file number 255091. Record should reflect Mr. Trepanier is present here in the courtroom today. Council appearances on.
Ryan Ziegler, Your Honor.
Thomas Seeger, current with, the Mr. Trevania.
Mr. Seeger, how did we want to proceed on this file?
Your Honor, it's my understanding that the people have offered Mr. Trevania an opportunity to plead to one count of possession of methamphetamine and one count of OWI second, with no habitual offender notice.
Is that a correct statement, Mr. Ziegler?
It is, Your Honor.
Mr. Trepanier, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes, sir.
And is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Trepanier, are you currently on any kind of probation or parole?
Yes, sir.
You understand that the maximum possible penalty you could face for possession of methamphetamine is up to 10 years and or $15,000 fine?
Yes, sir.
And the maximum possible penalty you could face for operating while intoxicated as a second offense is up to 1 year in jail with a mandatory 5 days in jail. Do you understand that?
Yes, sir.
With all of that in mind, what is your plea to those two charges today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to do that by leave, which means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
Yes, sir.
Has anyone promised you anything other than what we said here in court today?
Yes, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to each of these charges because you are actually guilty?
Yes, sir.
The information I have indicates this happened, looks like quite a while ago, back on July 14th of 2022. Is that the correct time frame?
I think so, sir. Yes.
Okay. Back at that time, were you present here in Kalkaska County?
Yes, sir.
And on that day, had you consumed some controlled substances?
Yes, sir.
After you consumed those substances, did you operate a vehicle on Hall Road here in Kalkaska County?
Yes, sir.
Did your use of those substances interfere with your ability to safely and normally operate a vehicle at that time?
Sure.
Okay.
What that means, you're. What you're asking,
So, did,
did I think that it? I'm sorry.
yeah, sure. Mr. Seeger, do you have any more information about the underlying facts of this?
Well, Mr. Trepanier, during that time period, you're using drugs, correct?
Yes, I have. Did.
All right, and you're not disputing that it affected your ability to drive, correct?
And at that time, did you have possession of some methamphetamine?
So,
Okay. Did you have any legal right to have any amount of that at that time? Okay. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, sir.
Mr. Seeger?
Yes, sir.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
And counsel, are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Mr. Trepanier, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. In the meantime, somebody from the probation department will be in touch with you for a pre-sentence report. It's important that you follow up with that and that you stay in touch with your attorney, Mr. Seeger. And Ms. Wagner, did you want Mr. Trepanier to come over to the probation office here today?
Yes, please. Thank you.
Okay, so Mr. Trepanier, if you can just go across the way to the probation office to pick up the packet before you leave court today.
okay, thank you.
Okay, thank you. People versus Alyssa Rickley, file number 255102. The record should reflect Ms. Rickley's present here in court today. I could have counsel put your appearances on in this file.
Ryan Ziegler, yeah, people, Your Honor.
Thomas Seeger, apparent with on behalf of Ms. Wrigley.
Mr. Seeger, how did we want to proceed in this case today?
That's my understanding that people have offered Ms. Wrigley an opportunity to plead to one count of attempted resisting and obstructing. Additionally, Your Honor, it's my understanding that people have no objection to immediate sentencing to the extent that the court is willing to do.
Mr. Ziegler?
Fair statement, Your Honor.
Okay, Ms. Rickley, have you had a chance to talk to Mr. Seeger about this plea agreement?
I did this morning.
Did you need any more time to do that before we proceed today?
No, Your Honor.
All right, can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Just need you to say yes or no.
Yes.
When they do a transcript, they don't know what.
Okay, I'm sorry.
It's okay. Okay, so you understand that this offense of resisting or obstructing as an attempt carries with it a maximum penalty of up to 1 year in jail. Do you understand that?
I do.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do, Your Honor.
You understand that you're giving up and waiving those rights by pleading guilty.
I do.
Has anybody threatened you with anything to get you to plead guilty? Anybody promised you anything other than what we said here in court? Home free choice to enter this plea.
It is.
Are you pleading guilty because you are actually guilty?
Yes, Your Honor.
The information I have indicates this happened on July 25th of this year. Is that the correct day?
Yes.
On that date, did you come in contact with a deputy from Kalkaska County Sheriff's Department?
I did.
Did you know that that deputy was there to perform his duties as a law enforcement officer?
Yes.
And what did you do to attempt to resist or obstruct or oppose that officer at that time?
I basically just wasn't complying with his orders. I didn't want him to come into my house. So, yeah, I was under the influence and I wasn't thinking straight, so I made some bad choices.
Okay. And this occurred during the course of an investigation that that deputy was conducting.
Correct.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No,
Mr.
sir.
Seeger?
No, sir.
And counsel, are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Ms. Rickley, you do have the right to have this hearing set on a separate date and to have a pre-sentence report prepared. Give me more information about all the circumstances. You can waive that right and we can proceed with sentencing here today. Mr. Ziegler, are the people going to be asking for the court to impose any jail time in this case?
No, Your Honor.
So how did you want to proceed?
I don't know, I guess I do have one thing to say though too. I don't know if you've seen, no, don't say it, okay. Okay, never mind.
Did you want to go forward with the sentencing portion today?
Yes.
Mr. Ziegler, anything that the people would like to say in terms of allocation?
Your Honor, I think this was a very, as she's already said, a poor decision on Ms. Wrigley's part. She was intoxicated. Police were there to investigate alleged domestic involving her. Both of the parties involved in this alleged domestic were very uncooperative with police. When police attempted to enter the home, following Ms. Wrigley into the home, she resisted their efforts to make entry and she put her hand on one of the officer's chests. And that led to a physical altercation where she was restrained. She only has one prior conviction, by knowledge. That's impaired from about 15 years ago. I don't see that any jail time is appropriate in this case. I think this is a learning lesson from Ms. Wrigley. I think she regrets her behavior. I believe she's been through some kind of treatment. And I think fines and costs are an appropriate sanction at this time. I don't think there's much benefit to jail or to further monitoring. Either she has learned a valuable lesson from this incident or she has not. And she will either come back before the court or she.
Thank you, Mr. Seeger. Anything on behalf?
Likewise, Your Honor. Similarly, I generally follow the recommendation on allocation of the prosecuting. And speaking of Ms. Wrigley, not just today, but other instances, including yesterday, she has expressed a great deal of remorse. She does recognize that what she did was wrong. She accepts responsibility for it. She's hopeful to put this behind her and move forward.
All right, thank you. Ms. Rickley, was there anything that you wanted to say today?
No, thank you, I appreciate what both of them just said. That summarizes it.
Yeah, so it sounds like there was some alcohol involved. Sometimes that gets people in a state of mind where they do things that they might not otherwise do, either with regard to other people that they're related to or in relationships with. Sounds like this was part of a domestic issue. And then when police are called, they're there to do a duty. They can't just leave when there's things like that going on. They have to investigate it and they have to be satisfied that everybody's safe, because if they don't do that, then they're going to get in trouble. And a bigger point is it could lead to somebody being harmed, and that's what police are there to prevent. So it sounds like generally you're not somebody who gets themselves into trouble. And so I'm satisfied based on what the lawyers have said that this is something that was just a bad day for you and that you're going to be able to move on from. There are different ways that the court can punish wrongful conduct. One of those ways is, of course, jail. The other way is through your pocketbook and imposing fines.
Right.
And in this case, I think that that is a sufficient punishment to impose and to impress upon you
Okay,
that you need to avoid this kind of conduct going forward. So, court, did you spend any time in the jail as a result of the arrest in this case?
just then it was a Friday, so I didn't get out till Monday.
Okay, so 3 days.
Yeah.
So the court will impose 3 days in the Kalkaska County Jail with credit for 3 days served. The court will impose, are you appointed in this case, Mr. Seeger?
I was, Your Honor.
The court will impose court costs of $325, an attorney fee of $350, a $50 state cost, and a $75 crime victims assessment. Once we're done here today, just go across the way there to the clerk's office to make arrangements to
Okay,
pay those fines and costs. You do have the ability to appeal the sentence. If you wanted to do that, you would have to file for your appeal within the next 21 days. If you have more questions about that, Mr. Seeger would be able to help you with that.
okay, Your Honor, thank you.
Mr. Ziegler, anything else we need to address today?
No, Your Honor.
Mr. Ickley, good luck to you going forward.
Thank you so much, sir.
People versus Cooper, file number 255061.
Good morning, sir. Thomas Seeger, appearing on behalf of Mr. Cooper.
Thank you. The record should reflect Mr. Cooper's present here in the courtroom today. This is the date and time set for a sentencing hearing. And Mr. Cooper, did you have an opportunity to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes.
Do you need any more time to do that before we proceed?
I don't think so.
Mr. Seeger, are there any additions, deletions, or corrections?
You're not, Your
Are there any challenges to the scoring?
Honor. You're not.
Mr. Ziegler, did the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Yes, Your Honor. I understand that rehabilitation is always the starting point for any defendant at any sentencing. But this case is different. Mr. Cooper is before the court for his 10th felony offense. He's been committing felony offenses for the better part of 5 decades. His first offense was a burglary in 1970 at age 18. He was discharged from probation without improvement in that case. His most recent offenses were an armed robbery and a retail fraud first degree. Both of those were committed in 2001. He did not discharge from parole until 2021, 20 years later. And just a few short years after that, he's back before this court for a new felony offense at the age of 73. I think the court in 1970 had it right. Mr. Cooper has been repeatedly discharged from supervision, but without improvement. Facts of this case are also concerning in the light of a possession case. Mr. Cooper was seen by the Traverse Narcotics team leaving a known drug house. He was pulled over shortly thereafter. He was found with a meth pipe, a gram of meth, and over $2,000 worth of cash. But he did not have enough weight or other surrounding circumstances to pursue an intent to deliver charge. The fact that a man of his age and criminal history is visiting a known drug house, is possessing and using methamphetamine, and has significant quantities of cash when stopped is all highly troubling. The guidelines in this case are 10 to 23, and frankly, a sentence of probation is only on the outside of the realm of reasonable outcomes in this case, Your Honor. Rehabilitation is a worthwhile goal when someone still has time left to reform their life, and when they have not had numerous opportunities in the past to do so. Mr. Cooper is 73. He's been on probation or parole 7 separate times in his life. I do not wish to discount Mr. Cooper's recent period where he has not been in significant trouble. That's certainly to his benefit. But I do wish to make the case that he is simply out of chances, Your Honor. Why the PSI author believes that the 8th time in this case is going to be the charm is beyond my reckoning. I see no reason to give Mr. Cooper additional opportunities at probation. I think there is a good case here for prison. Punishment is certainly deserving. Deterrence, both individual and societal, would be served by sending him to prison, would also allow him to return to parole status at the conclusion of his sentence, which he did well on for some time previously. Given all of that, Your Honor, I think a sentence of 13 months in prison is perfectly reasonable. It's on the lower end of the guidelines, but it would accomplish all of the goals of sentencing. So that's what I would ask the court to do today. Thank you.
Thank you, Mr. Seeger.
Your Honor, I humbly disagree with Mr. Ziegler and his assessment. I think that Lockridge is the case that somewhat controls in this case, and as much as I understand that maybe Lockridge is used in different ways by the courts, I think that the intellectual underpinnings of Lockridge allows the court in limited circumstances to depart downward in situations where it would be appropriate. I don't discount that Mr. Cooper has a long, extensive criminal history, because clearly he does. Or I would know, as Mr. Ziegler pointed out, that his last conviction was in or around 2001. And so he's gone 24, 25 years free of any kind of trouble whatsoever. And it just so happens that in this case, he was using drugs because he was somewhat self-medicating because he had lost somebody that was important to him. He was clearly not making good decisions during that time period, but he was in fact using drugs. I do understand that Mr. Ziegler has concerns about the amount of cash that was found on him. Mr. Cooper explained the reason why I had that money was because I was going to pay for my brother's cremation. And so that was the money that he had available to him. I also disagree with Mr. Ziegler in terms of what a large quantity of cash is. For the older generation, Your Honor, my grandmother, when she passed away, she had large sums of money all about her house, under the bed, in drawers, things of that nature. She was still of that generation where she was carrying large sums of cash. I don't really particularly think that $2,000 is a large sum of cash. He does have an explanation as to why he is in possession of that money. He clearly went to that house to obtain drugs. The report indicates that when TNT was viewing the house that he went to, those were the people from Muskegon that were apparently or allegedly selling drugs. There's no allegation whatsoever that Mr. Cooper was selling drugs. He merely went there to purchase drugs. And so I think that this case is somewhat distinguishable. If you look at things in a vacuum, yeah, it's true he does have a long, extensive criminal history, but it's also true that if he had not been on parole status, he would have not gotten any points whatsoever. So if he wouldn't have been released from his parole status in 2021, he would have gotten 0 points in all of his PRVs, and he would have probably had like a 0 to 6 or 0 to 9 recommendation. He's 71 years old. He's an older gentleman. I'm not saying that he hasn't had opportunities, but I think that any person can change. I think that there are situations where people struggle with their own personal situations where they make decisions that maybe they ordinarily wouldn't. And that is maybe one of those things where people use alcohol, people use drugs, people struggle personally, and that's Mr. Cooper. But be that as it may, Your Honor, it appears to me that he is capable of change. He's done reasonably well on bond. He has been in constant communication with me. I don't see how jail and or prison changes anything for Mr. Cooper. I don't see how it's a benefit to society. He's elderly as they get closer to 70, but he's definitely an older gentleman. I don't see how sending him to prison over simply using an illegal substance is fair or reasonable. I don't see how jail changes anything for him. If anything, I think the probation officer has it correct that the reason why we would put him on probation is for supervisory reasons, to ensure that he's not using drugs, to ensure that he's going to continue to stay out of trouble. And if he was just recently released from parole in 2021, well, that means that during that whole entire period of time, he didn't end up getting in any additional trouble. So he did do very well for over 20 years. So I don't think he finds himself in this position, but for loss, and it's unfortunate for him. He's not trying to say that he wasn't in possession of drugs. He didn't try and play the game in any way, except the responsibility for it. And so he's just asking the court for an opportunity. And so I would ask the court to, one, place him on probation for a period of time, and two, not impose any immediate upfront jail, and to suspend the balance of any jail that he could potentially face. But if he should violate the conditions of his probation, and he just goes to jail for whatever period of time the court deems to be just and reasonable. But again, I don't think that Mr. Cooper or society benefits by sending him to jail for an appreciable period of time. I certainly don't think that prison would be an appropriate remedy in this case. Again, Your Honor, I think that there is a large distinguishment between somebody who is doing something in terms of using an illegal substance as opposed to somebody who's selling it. Somebody who's selling it, that's definitely a different situation than somebody who's using it. And in as much as it wants to be depicted as a person who's selling drugs, there's, as Mr. Ziegler pointed out, there wasn't any kind of indicia that he was in fact selling them other than cash that was found in his person, which again, Mr. Cooper has an explanation for. And again, I don't find that to be a very large sum of money. But be that as it may, Your Honor, he recognizes what he did was wrongful. He recognizes that he does have a prior criminal history. He's just asking for an opportunity to be placed on a term of probation, which would be consistent with the recommendation of the Department of Corrections, which again, under Lockridge, does not require any immediate jail.
All right, thank you. Mr. Cooper, anything you wanted to say today?
Yes, Your Honor. I agree with the prosecutor. My whole life I've been in trouble. I've done nothing but wrong my whole life. But since I've been out this last time, I've done nothing but good. I've tried to help do for people. I made amends to people I've hurt. I lost my mother, my brother. If I was like I was years ago, I would have turned right back around and started doing that. But no, I didn't. I lost my disability. I struggled. And I went to drugs, which I knew I shouldn't have. And then I knew that, and I was seeking treatment. If I could have got my treatment before I got arrested, there were circumstances I couldn't get into the program. And I didn't go to that house to get drugs. I was working. I was delivering a pizza to that place. I didn't even know there was a drug house. When I got arrested, I didn't deny. I handed it right to him and told him I was wrong. But if I was like I was years ago, I would have changed. I would have went right back to it. But I am not that person anymore. It took me these many years to learn. And I don't want to waste any more. I have more left, too many years left. I lost everybody. I got my 2 little dogs. That's all I got left. I got some good friends now. I never used to have friends. I got people that care for me now. And I never used to care for people, but they taught me how to care. And if I was like that person years ago, I wouldn't even be here right now. And I'm in treatment now. If I could have gotten treatment, I was talking to a treatment program 2 months before I got arrested. And for some reasons, insurance, I couldn't get in it. But I'm in it now. I've been in it. I'm doing good. I don't believe I can do time. You can see my past record. I've done nothing but been locked up. I got no problem with being locked up. I can do locked up. But I don't want to be locked up. I'm finally out of all that. I'm sorry. I'm done. I'm sorry.
Okay. All right. I had a chance to review the report prior to the hearing today. So I'm familiar with the circumstances that bring you before the court in this case. I'm also familiar with your past history, your record, and so forth. And I take all of that into consideration along with what both the lawyers have had to say and yourself. I think there's a couple of compelling factors here. Number one, your past history obviously follows you. And you know, it puts you in a position where you don't have the luxury of making mistakes anymore because you're going to result in higher guidelines just based on your past history. So, you know, you're somebody that, like I said, just you don't have the luxury of indulging when you're having problems in substances, because if you get caught, you wind up with more serious guidelines. In terms of the circumstances here themselves, I don't, you know, the cash certainly is suspicious to me. There's no connection. Obviously, I think if the prosecutor could prove it, there would have been different charges. But I think it's awfully coincidental that you happen to have a fairly large amount of cash on you. I know you got an explanation for it. I heard your attorney. I'm just saying I don't know whether I believe that explanation or not. Under the circumstances, it's awfully coincidental. But be that as it may,
I mean, I could.
you're not charged with that, and that's not what we're here for. The other, I think, compelling factor, and I think Mr. Seeger pointed it out, is you were on parole for a long time, and absent that, your guidelines likely would have looked a lot different because some of those would have been subject to the gap rule. So I think I should take that into consideration in terms of what an appropriate sentence is, even if it doesn't necessarily affect your guidelines. I agree with the prosecutor. I don't think probation is appropriate. I don't think at this point, you know, there's any value to the community and putting community resources, given your past history and long supervision. I think given the underlying circumstances, given the gap in convictions in this case, despite your parole status, I don't think a prison sentence is warranted, but I think a jail sentence is certainly warranted by your conduct in this case and your past history. So the court is going to sentence you to 12 months in the Kalkaska County Jail. You do have credit for 4 days served. The court is going to order that you pay crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of the sentence, and Mr. Seeger, if you can get those appellate rights and provide those to Mr.
Just for the record, we're trying to have it spelled out.
Mr. Cooper, you are remanded to the custody of the county at this time. Good luck to going forward.
Thank you.
That's right, Mr. Cooper.
Thank you.
Do you know if we have Mr. Riley?
Yes, he is in holding.
Are you Miss Merritt?
Right.
Okay, it's gonna be a minute before we take your case, okay? I'm just gonna ask you to have a seat there.
Ready for Mr. Riley?
Mr. Riley, I'm gonna have you go right to that podium there, please. We'll go on the record in People versus Nicholas Riley, file number 194282. The record should reflect Mr. Riley's present here in the court today. If I could have counsel put your appearances on.
Frank, you're gonna get.
Morning, Your Honor. Gerald Chaplow appearing on behalf of Nicholas Riley.
All right, Mr. Riley, this is the date and time set for sentencing. Have you had a chance to go through the pre-sentence report with Mr. Shefflow?
Yes.
Okay, Mr. Shefflow, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Don't have any guidelines. Mr. Ziegler, do the people have any additions, deletions, or corrections?
One minor change, Your Honor, on the top of both the face sheet and the recommendation page, it refers to the OWI second as an attempt, OWI second. It should just be an OWI second.
Mr. Shefflow, any objection to that correction?
None, Your Honor.
Okay. Any other changes, Mr. Ziegler?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, Mr. Riley has been absconding for the past 6 years, and in that time has committed another OWI offense, his fourth. He obtained significant benefit from a plea agreement in this case that he entered into back in 2019, and then demonstrated that he was not deserving of that benefit by absconding and reoffending. I don't know what he is likely to get in Grand Traverse County, but I see no reason why this court should give him any leniency on these 3 offenses, simply because it happened back in 2019, or simply because he might be subject to another sentence in Grand Traverse County. The defendant should absolutely be subject to a year in jail on each of these offenses. So that's what I asked the court to do.
Thank you, Mr. Shefflow.
Thank you, Your Honor. Prosecution is correct. Mr. Riley did get the benefit of a bargain at that time. Court notes the things that were going on in his personal life. The positive that I can note is that I've asked Mr. Riley, I've done my own investigation to the extent that I could, but his last offense date was August 14th of 2021, and he has been out of all trouble since then. That was the Grand Traverse County case. He was charged with a felony. He's been convicted of a felony, and he will be sentenced on that case December 15th. He's been in jail since June. That's noted in the report as well. At the time that he was finally picked up, this was involuntary. He did not turn himself in, but he'd come back to the area finally. And he had a good job. We even had a letter, but it's really too old to present at this point. But that was from July that the job still was available for him should he have remained on bond, but really was not the case, or really wasn't appropriate for him to be released given the circumstances. Again, I also have no idea what Grand Traverse County is likely to do in that case. They have run his guidelines. I do have a copy of that pre-sentence investigation report present with me today. Guidelines in that case are 0 to 17 months. So given the circumstances, yeah, may go to prison. I don't know. This is definitely a different case. The strength, I guess, is that since 2021, he hasn't been in trouble, spoken to his mother. He's really in a phase of trying to grow up, trying to get his life back on track, actually get a job, work the job, and just stay out of trouble. And that was his plan. That's what he's been doing. So on paper, this does not look good. And he had his reasons why he wasn't mentally ready to take care of things. Explain those reasons, but he's ready to take care of it now. Also like to note that there's a Manistee County case from 2014. While he's been incarcerated, he's gone to Manistee, it's misdemeanors, and he has fines and costs to pay on that. And I think he had some savings from when he was working, and he's working with his mom to try to get that paid as well with Manistee County. So getting things taken care of. Manistee was the first case. That was the oldest. Then this was the next one. Traverse City is the last one. And once he's got that taken care of, all of that taken care of, he can actually get on with his life. He's not a kid anymore and 36 years old. He recognizes that. And I think when he's done with the punishment phase for all of these cases, he definitely has to get serious about this alcohol issue that he has. Maybe get to the core reasons why he has the alcohol issue, but also recognize that if he starts drinking again, he'll be back in front of some court somewhere. And that's not where he wants to be, because it's very likely at that point in time, a prison sentence, assuming that that's not what happens in Traverse City. Again, I don't know that to be the case. We've talked about that here. So the best that I can say is got to keep getting things wrapped up, keep moving in the right direction. We asked this court to consider that. What I was more looking for was, given that we're not even sentenced until December 15th in Traverse City, was to just terminate this case with time served, some appropriate fines, costs, and fees with no supervision, given that he's going to be remanded to jail anyway, and then will be on some form of either prison or additional jail, and definitely parole or probation out of Traverse City. Having the overlapping supervision may not be the best use of resources, given that they're probably going to be a felony supervision rather than misdemeanor supervision, Your Honor. But I also understand the seriousness of what happened here, and definitely would have liked him to have taken care of it sooner, because he was already through the plea phase. It was a sentencing, and he could have been done with all of this long ago. Thank you, Your Honor.
All right, thank you. Mr. Riley, anything you wanted to say?
Just what he was stressing is that I was just in a wrong mental state. I almost died in a house fire in Traverse. I was borderline homeless, and I just wasn't in a mental state to do anything. If I was on probation, I just would have messed up and screwed everything up anyways. I'm just moved back to Michigan. I'm trying to get my life back in order. Going through the steps right now. I wish I had some more money, or wish I had taken care of it sooner, but I'm doing it now, and just hope I get it done quickly and get on with my life.
All right, I did read through the report, so I'm familiar with the facts of the underlying offense here. Obviously, I took the plea back in 2019, but I didn't remember that far back. So the report gave me an opportunity to kind of refresh myself on your case and what the underlying facts were, as well as your individual circumstances. There's a lot of information in there about what's gone on since then in terms of your other issues in Manistee and Grand Traverse. I take all of that into consideration, along with what the lawyers have had to say here today. This was a serious offense, the underlying offense. The conduct that you engaged in, certainly the court has an interest on behalf of the community in punishing that kind of conduct to be a deterrent to you and to others. Your actions in absconding and evading the sentencing in this case for 6 years is also something that I think deserves punishment. People need to understand that you can't just disappear for 6 years and then show up and expect to just get time served from what you served back in 2019. I think there's an additional penalty that needs to be paid for that, not only so that you understand it, but that other people see, and as a deterrent, that if you're going to do that here in Kalkaska, at least, it's going to be met with additional punishments. And so for those reasons, I agree with Mr. Ziegler. And for the reasons I've stated, I think that the maximum of 1 year in jail on each of these charges is appropriate, given all the circumstances. So the court is going to impose 12 months in jail as to each of the 3 charges. The court is going to allow for 139 days of credit. Those sentences will all run concurrent to each other. Crime victims assessment of $75, court costs of $325. I'm sorry, Mr. Sheffler, are you retained?
I am retained now, but Mr. Seeger was actually an attorney that took the plea in the case.
Okay. I'm going to strike the attorney fees So court cost of $325 and a state cost of $153. You do have the ability to seek an appeal of these sentences because they are misdemeanor offenses. There won't be any written appellate rights. Mr. Sheffield, you had an opportunity to go through Mr. Riley's appellate rights with him. Okay. All right. Mr. Ziegler, anything else we need to address on this file today?
No, Your Honor.
Mr. Sheffield?
Just that my understanding is that Mr. Riley would be going back to Grand Traverse County at this point in time, Your Honor.
I believe so.
All right, thank you, Your Honor.
All right, thank you. Good luck to you going forward.
Oh, here we go.
There at Calhoun, is that Mr. Armstrong? Is that you?
Yes, Your Honor.
Mr. Mataloni, are you able to hear me okay?
I am.
Okay, we'll go on the record in People versus Armstrong. This is file number 234838. The record should reflect Mr. Armstrong's appearing today by video from Calhoun County Jail. If I could have both counsel put their appearances on.
Ryan Ziegler, on behalf of People, Your Honor.
Good morning, Mike Mataloni on behalf of Mr. Armstrong.
So Mr. Mataloni, in this case has been kind of languishing. I know that you've just been retained as counsel fairly recently. I believe that there's a new violation that I need to arraign Mr. Armstrong on today. And then it's my understanding that you wanted to have these both set for a later date. Is that correct?
Well, my understanding was, Judge, that the court wanted to do that because you're going to arraign him today, and it's with both of us on Zoom. It's difficult to try to negotiate a plea, but my client is ready to enter a plea on these violations. I would ask the court to arraign him today and then set it for a probation violation plea. And then if I could have the probation officer just let me know how to get in touch with them.
Okay, Mr. Ziegler, do you have any objection to that?
No, Your Honor.
Okay. All right, so Mr. Armstrong, I'm just going to go through your rights with you on this second alleged violation that was initiated in July of 2025. Number one, I want to make sure you understand what the alleged violations are. It's alleged that you violated your probation on July 7th of 2025 when you were arrested and charged with disorderly conduct in Jackson County, and when you were arrested and charged with resisting or obstructing in Jackson County. Do you understand what the alleged violations are?
Yes, Your Honor.
And you understand that you have the right to have a hearing as to whether or not you did violate your probation as alleged?
Yes.
All right. And Mr. Mataloni, I'm assuming Mr. Armstrong wants to enter a not guilty plea as to both of those today?
At this time, yes, Judge.
All right, so the court will enter not guilty plea on behalf of Mr. Armstrong with regard to both the alleged violations. The court will set this look for a probation violation hearing and plea in about 30 days, along with the previous violation from 2024. The court will set bond in the same amount for this violation as the previous violation pending that hearing. And Mr. Mataloni, I guess my only question is, do you know whether Mr. Armstrong's still going to be lodged there in Calhoun in 30 days?
Yes, he'll still be there.
Okay, so we'll set this for a hearing. If we can have Mr. Armstrong written for that hearing by video. And then Mr. Mataloni, I see Ms. Wagner, the probation agent, is on here. Did you have a question for her?
Just is it okay to email her and, regarding trying to, settle this matter?
Yes, Mike, did you not get the email I sent you a couple of days ago on this matter?
I don't think I did. If you could resend it, it might have went to my junk mail.
Okay, I will resend you another one right now.
Okay, and then, we'll try to resolve it before we get the date.
Okay, sounds good. I'll reach out to you this week. Thank you.
Thank you very much. Thank you, Judge.
All
Thank you,
right,
Honor.
that's, Mr. Armstrong, did you have any questions at all?
And you said, my bond was set for the same. Could you tell me what my bond was, sir?
Yep, we can do that. Hold on one second.
Okay.
$10,000 cash or surety.
Okay. Thank you, Your Honor.
Okay. All right, thank you. All parties on this file are free to disconnect at this time.
Thank you, Judge.
Thank you.
All right, I need to take a short recess. We'll come back on the record in about 5 minutes. That's okay. Ms. Merritt, if you want to come forward, please, we'll go on the record in People versus Shelley Merritt, file number 255074. The record should reflect Ms. Merritt's present here in the courtroom. This is the date set for sentencing in this matter. Ms. Merritt, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes.
Mr. Seeger, are there any additions, deletions, or corrections?
They're not here.
Are there any challenges to the scoring?
They're not here.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor. What was that?
Anything on behalf of the people for allocution today?
Your Honor, I think Ms. Merritt desperately needs treatment for substance abuse. And the 7411 sentence gives her a good incentive to do so. She's already subject to orders in another case, civil abuse and neglect matter. And giving her a chance to keep her record clean as she works towards her sobriety and to the return of her children gives her extra incentive to be compliant and to work towards those goals. She has no criminal history. And while I certainly do have some doubts that she will take full advantage of this opportunity, I sincerely hope that she does. I do not like coming back to court for failed 7411 deferrals. And I certainly don't like filing petitions to terminate parental rights. And right now, Ms. Merritt stands at a stark crossroads. She can either sober up and take back control of her own life, or she can continue to use and face the consequences of that poor choice. I would ask the court to give her the benefit of a 7411 sentence with the hopes that she takes full and complete advantage of it.
Thank you, Mr. Seeger.
Yeah, likewise, I would just ask the court to give her the benefit. That's really nice. That treatment is going to be a beneficial thing for her. It's my understanding that following this hearing and later today, following her visit with her children, that she will be checking into a substance abuse treatment program, which is a condition of another court order that Mr. Ziegler had alluded to. So she's trying to work her way through the case service plan. I do recognize that there are bumps in the road for people who have substance abuse problems from time to time, but I'm always hopeful that they'll be able to work their way through it. Ms. Merritt has expressed a lot of want to remain sober, if for no other reason, to build her familiar relationship with her children that has been very hard on her, very difficult for the family, and she's trying to do right by everyone, including herself. So to that end, I would just ask the court to give her the benefit of 7411. I don't necessarily have doubts, I guess I have concerns, but I'm hopeful that she'll be able to successfully complete things. She's always been very good with communication. She's always been very good with accepting fault. And I think she's now come to a point where she just wants to try to change her life. Whether or not she'll be successful, I guess that's always a difficult question. But any amount of treatment can only help. I don't see that as a detriment to anyone. She's expressed a want to engage in those services.
Thank you. Ms. Merritt, anything you wanted to say today?
No, sir.
Okay, I read through the report. I'm familiar with what happened in this particular case, as well as your background and your circumstances. And, I think you need to get into some treatment. You don't look good here today. And you're using some really dangerous substances. What you had with you on the date of this incident tested positive for fentanyl. And as I'm sure you well know, that's people die from using fentanyl laced substances all the time. Very unpredictable. And when you're using any kind of substance, you don't know what's in it until it's too late. And so to the extent that you can use this probation to get some resources, to get some help, if you don't already have it lined up.
I do.
I really hope that you do. Because otherwise you're at risk of not being around. And I don't think any of us want that. So I hope that you will take that opportunity. I'm going to place you on probation. I'm gonna hold some jail time in abeyance. If you are able to complete your probation, you would never have to serve that jail time. However, I'm going to impose it, but hold it in abeyance, hopefully as an added motivation to you to follow through with your treatment and with your health. So the court is going to place you on probation for a period of 18 months. The court is going to adopt as the conditions of the probation all the terms and conditions that are listed in the report. The court is going to impose 90 days in the Kalkaska County Jail with credit for 1 day served. The court's going to hold that time in abeyance. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, the DNA testing fee of $60, and a $65 state cost, in addition to a $30 supervision fee per month while you're on probation. The court will impose a probation pursuant to 7411, which it does appear you are eligible for. So there are no appellate rights at this time. Ms. Wagner, did you need Ms. Merritt to stop by your office before she leaves court today?
Yes, please. Thank you.
So Ms. Merritt, you just need to go over to Ms. Wagner's office across the way there. Yeah. Yeah. Good luck to you going forward.
Thank you.
All right. You're all done. Deputy, can you let Mr. Travis know we're ready for him? You let Charlotte know.
Okay, yeah.
Okay, Mr. Travis, we have Mr. Ross connected. And Ms. Beta, are you connecting on the Ross matter?
Yes, I am, Your Honor.
Okay. We'll go on the record in People versus Aaron Ross. This is file number 244882. The record should reflect Mr. Ross is connected today by video. And if I could have both counsel put your appearances on, please.
Kyle Travis on behalf of
Christina
Mr.
Bate on
Ross.
behalf of the attorney.
Okay, so we've been trying to get this hearing for a while. We had some issues being able to locate and get a hold of Mr. Ross, but we're all present today. This is set for a sentencing following what I view, and Ms. Beta, you can correct me, but would be an unsuccessful delay of sentence. Is that correct?
I would agree, Your Honor.
Okay. Mr. Travis, is that how we're proceeding from your standpoint as well?
That is, yes, as indicated in the report, there were financial obligations to get certain benefits from the delay, and Mr. Ross did not meet those.
Okay. All right. So Ms. Beta, is there anything you wanted to say for sentencing on behalf of the people today?
We would still it's the discretion of the court, Your Honor.
All right. Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, largely we would ask the court to follow the recommendations. Mr. Ross did serve a significant amount of jail time on this matter. He was hopeful to try and, protect his record by completing some parts of the delay. At certain points in this, Your Honor, we did, I think, a 6-month review, and he was doing quite well in moving along. He's unfortunately had a lot of troubles in his life recently, and has struggled to complete the terms of the delay. And speaking with Mr. Ross this morning, he's getting things back on track. He's got employment. He's back working. His legal issues are behind. His other legal issues are behind him. He was actually never charged on any of that. He did do, I think, almost 2 months in jail, but ultimately they did not receive the charges. So, I don't think any more jail time is really needed. The important thing is Mr. Ross is working, and He's having some struggles with FOC because he's struggling to access his account that he had set up because his.
I don't want to cut you off, Mr. Travis, but we're quite a bit behind. So if we could just stick to what I really need to know in terms of sentencing here.
Thank you.
Without all the minor details, please.
So largely, Your Honor, we would ask you to follow the recommendation. Thank you.
All right, thank you. Mr. Ross, is there anything you want to say today?
Just that I've been trying to do my best with everything, and it's been kind of hard with my ex. She's the one that made all the accounts, so I can't access anything. I've been dealing with Stacy at the FOC, and I have a really good job now. I'm the manager of this big semi shop, so I'm trying. I
All
have
right,
no
so
issue.
based on
Go ahead, sorry.
based on that's all right. Based on the terms of the delay in this case, really the benefit to you, Mr. Ross, was going to be the reduced charge. It's clear to me based on the report and what the lawyers had to say that the terms of the delay weren't met for whatever reason. It doesn't really matter.
Yes.
So the real, I guess, downside for you is that you're not going to be entitled to the benefit of the reduced charge in this case, which means that that felony will stay on your record. So the court is going to impose the time served. I think that's adequate given the circumstances, and that's 195 days. So the court will impose 195 days with 195 days served. The court will preserve any outstanding fines or costs, and of course, any outstanding child support. The court will order that the original charge be entered as the conviction in this case, which is that 4-year felony. Mr. Ross, you do have the right to appeal this sentence. You will be provided with an acknowledgement of those appellate rights, some paperwork that explains to you how to appeal if you wanted to do that, as well as how to request a court-appointed attorney to help you with that appeal. Your time limits on that won't start running until you actually receive that paperwork, but that'll explain all of that to you. Ms. Beta, is there anything further we need to address for the record from your side?
Your Honor.
Mr. Travis?
No, thank you.
Okay. All right, Mr. Ross, that's all for today. All parties on this file are free to disconnect at this time.
Thank you.
Judge.
People versus Gary Johnson, number. Is Mr. Johnson present?
He's in Wexford County Jail, Your Honor.
Wexford.
Oh, okay, I'm
They
sorry, I
wanna-
just wanted to.
Yeah, they can connect whenever they're.
Oh, okay, I'm sorry.
All right, people versus Galvanic. Mr. Galvanic Lodge.
So Mr. Galvanic was extradited to Colorado. We adjourned this to see what was happening there. He had gotten out at one point of the jail in Colorado. The number he contacted me from on Colorado, somebody said it was not his number, didn't know how to get a hold of him. I'm unsure if he's back in jail in Colorado or what was happening, unfortunately.
Mr. Ziegler, do the people have any information on Mr. Galvanic's matter?
Your Honor, all I was aware was the fact in August, shortly after the last hearing, he had bonded out. I'm unaware of whether he's been reincarcerated in Colorado or not.
Okay. All right, Mr. Ziegler, how do the people want to proceed then?
Your Honor, it's kind of a unique case. I guess I would ask the court to either give us another adjournment or any alternative to simply issue a bench warrant for him until such time as he could come back to Michigan.
All right, Mr. Travis.
Yes, Your Honor. Both of those are reasonable with maybe some more follow-up when you can confirm whether he's in jail in Colorado or not. But at the moment, I don't have a good phone number for him and just don't know his status, honestly.
All right, so I will set this for one more status conference. If we don't have any information on Mr. Galvanic's whereabouts at that time, the court will issue a bench warrant. Mr. Seeger, do you have Mr. Corbin present?
He's lodged in the web, you know, unless they brought him here.
No, he
Oh,
is.
they brought him here.
He's here.
Carter, he heard the same thing, but I was just wondering, for, there's a probation violation for a tetra there now. That's set at 11:30. I was just wondering if I can appear by Zoom. My understanding, just from speaking with the Department of Corrections, is that they're not. It's just not doing it.
Sure, yeah, I have no objection to that. Okay, we're on the record in People versus Adam Corbin. This is file number 255093. The record should reflect Mr. Corbin's present here in court today. This is the date set. Mr. Corbin, did you have a chance to go through the pre-sentence report and talk to us?
No additions, corrections, or challenges.
Okay. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor. Your Honor, I largely support the recommendations of the PSI. Mr. Corbin's 252 days to restore the competency during these proceedings. It's imperative that he continues to cooperate with CMH and take his medication as prescribed. I do worry that it's only a matter of time before he stops taking his medication and he again becomes a danger to himself or to others. However, in terms of the instant case, his guidelines are 2 to 17. A sentence of time served is squarely in the middle of those guidelines. And CMH can adequately monitor his compliance with medication and can petition the court for commitment should that become necessary. So I support the recommendation. I would also note my office has sent numerous letters to Great Lakes Energy seeking more information regarding any potential restitution. We've received nothing back from them. I expect that they will handle the damages civilly, so I'm not asking the court to impose any restitution at this time.
Thank you, Mr. Seeger. Anything on behalf of Mr. Corbin?
Likewise, Your Honor, I would just ask the court to consider sentencing to credit for time served, but I would ask the court to consider limiting court costs and fines in as much as he does have very limited means to be able to pay those. But also note, Your Honor, I have spoken with CMH. It's my understanding that they do have a treatment plan available for him once he's released from jail. So that they are working with him, all has been encouraged with it to ensure that once he's released, they did tell him that the recommendation was most likely that he would be released from jail. And so they have come up with a plan where they'll be transitioning him through the CMH. So hopefully that will give him some of the guidance that he needs, that will ameliorate some of the concerns that the customer has. And I don't think that you're here, but for him had any mental health problem, which is unfortunate. It's not necessarily something that one, a very unfortunate situation, but I think Mr. Corbin has gotten much better over the course of time. Speaking with him initially, it was very difficult to discourse with him. A lot of things that he was saying were not really particularly making sense. That's why criminal responsibility competency evaluation was requested. But over the course of time, I think that he has either been taking medications and he's somewhat ameliorated some of the problems that he's had. So he seems to be in a much better place than he was previously. So I would just ask the court to sentence him to credit for time served, but to limit his court costs and fines as much as reasonably possible. With the knowledge that he's not going to do this.
All right, thank you. Mr. Corbin, anything you wanted to say?
No, Your Honor. Sorry for your time.
All right, I did read through the report. I read through your letter as well. And I agree with what the lawyers have said. I think this was brought on by a mental health crisis. I know you're getting treatment for that. I hope that continues. And I am going to order time served, so you will be released today. So when you are released, I want you to follow up with community mental health.
Yes, sir. Right away.
Yeah, good, because you really need to stay with their program. That's going to help keep you out of jail and keep you safe and keep everybody else safe too. So the court is going to impose 252 days in the Kalkaska County Jail with credit for 252 days served. the court is going to order only the statutorily required costs, which is a crime victim's assessment of $130, a $68 state cost. You do have the ability to appeal this sentence, and Mr. Seeger, if we can just have Mr. Portman acknowledge receipt of this.
For the record, returning.
Good luck to you going forward, Mr. Portman.
Same with you, Your Honor.
Back on time by then. Terry, can you ask Bob to get in touch with Wexford, Gary Johnson?
I can email them too, Your Honor.
Okay, great, thanks. He's gonna contact him too, but if you could still ask Shop. Yeah. Thanks. All right. Is Rodney Taylor present? Mr. Taylor, if you come forward, please.
Yes, Your Honor. I hear Mr. Barnes is also mine, if he's up.
He's in Charlevoix, and they are going to be connecting. They're running behind as well. So.
Oh, okay, I'm sorry, I misheard that.
No, that's okay. So People versus Rodney Taylor, this is file number 255106. The record should reflect Mr. Taylor's present here in the courtroom today. And Mr. Travis, how did we want to proceed with Mr. Taylor's case?
Your Honor, it's my understanding that Mr. Taylor would like to accept a plea offer in this matter. My understanding that offer would be basically to plead to count one under a 7411.
Correct. Okay. Mr. Taylor, have you had a chance to speak with Mr. Travis about this plea agreement?
Yes, I have.
And is that how you wanted to proceed today?
Yes, Your Honor.
You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Mr. Taylor, are you currently on any kind of probation or parole?
No.
Have you ever been convicted of a controlled substance related offense before? Anything even related to marijuana, anything like that?
We asked him about this. He thought there might have been some 30 years ago, something related to marijuana. Mr. Ziegler and I both checked. I did an eye chat. Mr. Ziegler checked lean. We can see nothing. And Mr. Taylor's memory is not clear. I mean, he couldn't say what it was, somewhere in the lower thumb, he thought. We looked around. He did not recall the specifics, but he did, when asked, say, yeah, I think there was something 30, 35 years ago related to marijuana, but we can find no evidence of it in his, as he said.
Okay. All right. And Mr. Taylor, you understand that the maximum possible penalty you could face for this charge, which is possession of methamphetamine, is a felony of up to 10 years and or a $15,000 fine.
Yes.
With that in mind, what is your plea to that charge today?
So guilty.
Okay. So I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of your appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are in fact guilty?
Yes.
Okay. The information that I have indicates this happened back on February 24th of 2025. Is that the correct date?
Yeah, right around there.
Okay. And at that time, were you present here in Kalkaska County?
Yes.
While you were here in Kalkaska, did you have some methamphetamine in your possession?
Yes. Yes.
You had something that had methamphetamine in it or on it?
Yeah.
Okay. And did you have any legal right to have any amount of that substance at that time?
Can you repeat that?
Sure. Did you have any legal right, like a prescription
Oh,
or
no,
anything
no.
like that, that would give you a legal basis to have even an amount of residue on that?
No.
No. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
And are you both satisfied that the court has complied with statute and corporal limitation?
Yes, Your Honor. Yes, Your Honor.
Mr. Taylor, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Travis between now and then. Also, before you leave today, you're going to stop at the probation office next door. So make sure you follow up with that as well. Okay. Thank you.
Yeah.
Or, I'm sorry, get his on.
All right, we have a Mr. Boyle connected. Sir, can you tell me what case you're connecting on? You have to unmute yourself, please.
Sorry, the case number?
Is it your case?
It's for my son, Bryce Cologne Boyle. I can give you the case number. I'm sorry.
Okay. Okay, Mr. Boyle, I'm just gonna put you on hold until we call that case, okay?
Certainly. Thank you.
Then I'll bring you back in at that time.
Sure.
All right, at Charlevoix County, is this Mr. Barnes?
Yes, sir.
Okay, we'll go on the record in People versus Barnes. This is file number 255075. The record should reflect that Mr. Barnes is present today from Charlevoix County by video. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of People, Your Honor. Kyle Travis on behalf of Mr. Barnes.
Mr. Travis, how did we want to proceed with Mr. Barnes' file today?
Yeah, I think we need an adjournment, but because I need to confirm some things as to what's happened with Mr. Barnes and Charlevoix before Mr. Ziegler wants to make his offer, but we have moved along. He is in Charlevoix. I would ask the court to cancel last month, the court gave him a bond. If we could cancel that bond and set this for next month, and then I can get some confirmation on what's happened in Charlevoix for Mr. Ziegler, and I think we'll have a resolution at that point.
Okay, Mr. Ziegler?
I would agree, Your Honor. The offer is somewhat contingent on exactly what happened in Charlevoix. I think as soon as we have that information, we'll have a resolution.
All right, Mr. Barnes, were you able to hear all of that?
Yes, sir.
Do you have any objection to proceeding that way with your case?
No, sir.
Okay, so the court will order that Mr. Barnes' bond be revoked. The court will set this for a status conference plea hearing on its motion day in December. Anything further on this file, Mr. Travis?
Thank you.
Mr. Ziegler.
No, Your Honor.
Mr. Barnes, do you have any questions at all?
No, sir. I just got a question for my lawyer, if it's okay if I just ask him real quick. I just
Yeah,
need to get
as long as you understand that whatever you say is public record right now, that's all.
Yeah, that's fine. I just need a proof of incarceration from Kalkaska County. If you could send one to me.
I can reach out to the jail about that.
Yeah.
All right.
Okay, thank you, Mr. Barnes. We're going to disconnect this time.
All right, thank you.
Okay, at Wexford County, I just need you to unmute, please. Are you Mr. Johnson?
Yes, sir.
Okay, so we'll go on the record in People versus Gary Johnson, file number 255095 and 255107. The record should reflect that Mr. Johnson's present today by video from Wexford County. If I could have counsel put your appearances on in this file, these files.
Kyle Travis on behalf of Mr. Johnson.
Thank you. Mr. Travis, can you tell me the status of these two files today?
Yes, Your Honor. Mr. Johnson waived both these prelims. The offer made at the second prelim to resolve both files was an offer in the alternative, but Mr. Johnson would like to accept the version where he would need to file 255095 to the basically the charge, but dismissing the enhancements, and the other file would be dismissed in its entirety.
Is that a correct statement of the offer, Mr. Ziegler?
It is.
Mr. Johnson, did you have an adequate opportunity to talk to your attorney about this agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
All right, can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Johnson, are you currently on any probation or parole?
Probation in Grand Traverse County.
Okay, and is this plea today going to result in a violation of your probation there?
I'm not sure because the crime had happened on December 5th and I wasn't put on probation until December 14th or on February 14th.
Okay, is that your understanding as well, Mr.
That is our understanding.
Okay. All right, and then Mr. Johnson, you understand that by pleading guilty here to possession of cocaine, that the maximum possible penalty you could face would be up to 4 years and or a $25,000 fine?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have a right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty of this charge?
Yes, sir.
The information I have indicates this happened back on December 5th of 2024, so almost a year ago. Is that the correct time frame?
Yes, sir.
At that time, were you present here in Kalkaska County?
Yes, sir.
While you were here in Kalkaska County, did you have possession of some cocaine?
Yeah, I had a pipe, sir.
Okay, and that had cocaine on it?
Yeah.
Did you have any legal right to have any amount of that substance at that time?
No, sir.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Johnson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. In the meantime, somebody from the probation department will be in touch with you to do a pre-sentence report. Mr. Travis, anything further we need to address today on this file?
Nothing further, Your Honor.
Thanks, Mr. Ziegler.
No, Your Honor.
Thank you, Mr. Johnson. That's all for today, and the court's going to disconnect at this time. Do we have Mr. McGuire?
Yes.
Okay. Okay, we're on the record in People versus Jonathan McGuire. This is file number 234847. The record should reflect that Mr. McGuire is present here in the courtroom today. If I can have counsel put your appearances on.
Ryan Ziegler, on behalf of the
Kyle Travis on behalf of Mr. McGuire.
Thank you. This is the date and time set for sentencing in this matter. Mr. McGuire, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, sir.
Mr. Travis, are there any additions, deletions, or corrections to that report?
Not that I am aware of. Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, the defendant's before you for his fifth OWI conviction, priors in 2012, 2014, 2014 again, and 2016. With this offense occurring in 2023, this is the defendant's 21st conviction. On his last OWI third offense in 2016, he was given 23 months to 5 years. This offense, in terms of the actual conduct, Your Honor, was not the most egregious OWI. He was a .09, he was pulled over, he caused an accident. But in terms of the fact that he continues to commit felony offenses and continues to commit OWI offenses, that says to me that this offense should be treated much more severely than what the terms of the offense suggest. I'm a strong proponent that when you commit an offense, you receive a punishment, and then you go out and you commit that same offense again, your punishment should not get lighter. So while I think the recommendation of 16 months is a very fair recommendation from the PSI author, I can't endorse a sentence that sends a message that if you keep committing the same type of offenses, your punishments might be less next time. The last OWI was 23 months. I think this offense should be the same, only because to make it greater would warrant a departure, and I don't believe a departure is warranted. So I would ask the court to sentence the defendant to 23 months.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, obviously we would ask the court to follow the recommendation or something less. Obviously, Mr. McGuire struggles with drinking. Many of the things the prosecutor is pointing to are getting close to being almost a decade ago. He has tried to work on this, and I think he's committed to continuing to work on it. He knows he can't drink. As Mr. Ziegler noted, thankfully, this was not a particularly high BAC, but he pled to it. He's here, and it is illegal, and it is a felony, so he understands the situation he's in. But speaking with him, he has not given up on staying away from alcohol. Obviously, he has to because he's going to find himself in front of Your Honor. But he also is very motivated relative to being there for his family and supporting them. Thank you.
Mr. McGuire, anything that you wanted to say today?
No, sir, I think you pretty much summed it up. Mark.
All right, I did read through the report, so I'm familiar with what happened in this particular circumstance. There's also a lot of information in that report about you and your circumstances and background and so forth. And obviously, it's concerning to the court that you continue to come back with drinking and driving offenses, although this one, as Mr. Ziegler indicated, luckily nobody was injured or hurt or yourself. But again, the concerning thing is that this has now become a pattern. The other thing that concerns me is looking at your past history. You were on juvenile supervision 8 times, according to my report, and then probation 6 times. So the court really, after that many times, is out of options, and at this point is really in the position of looking at punitive sanctions and just, kind of not allowing you the ability to drink and drive anymore and endanger the public. So for those reasons, I do think that a sentence within the guidelines, but at the top end, is appropriate in this case. And so the court is going to sentence you to 23 months to 5 years in the Michigan Department of Corrections. You do have credit for 48 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and we're going to provide you with some papers, Mr. McGuire, that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with that appeal. Guard managed the custody of the state at this time.
Yes, sir. Thank you, sir.
Mr. Hines, present.
Yes, sir.
People versus Jerry Hines, file number 255079. The record should reflect Mr. Hines is present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler, Deputy Trial Clerk, on behalf of Mr. Hines. Yes, Your Honor. We've had discussions, and Mr. Ziegler made an offer last week to resolve the matter with a plea to a misdemeanor aggravated assault. And it's my understanding Mr. Hines.
What's the maximum penalty for that charge?
It's a 1-year trial.
Is that a correct statement of the offer, Mr. Ziegler? Mr. Hines, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes.
And is that how you wanted to proceed today? Yes. You raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Hines, are you currently on any kind of probation or parole?
No.
And as the lawyers have indicated, the maximum possible penalty you could face for this charge would be up to 1 year in jail. Do you understand that? With that in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty?
Yes.
All right, Mr. Travis, I'm going to ask that you conduct some questioning of your client on this charge.
So, Mr. Hines, back on July 15th, did you come into a conflict with a Mr. Wiesner?
Yeah.
And you guys were going back and forth with each other, potentially even threatening each other? Okay, but at some point during the course of that, did you grab a bow and arrow?
Yeah.
And point it at Mr. Wiesner?
Yeah.
And at that moment, you weren't claiming self-defense in that act? You were just angry at him for his bad behavior? So you're not claiming self-defense at this moment?
I don't think we got a verbal answer.
Yes.
Yes. So you did point the bow and arrow at Mr. Wiesner?
Yes.
Okay. And you're gonna be taking a plea to the lesser charge?
Any objection to the factual basis, Mr. Zipper?
I'm satisfied there's a factual basis to the greater charge.
All right. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you, Mr. Hines. The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Ms. Wagner, if we could just do a misdemeanor PSI on this so that I have a better understanding of the facts and some background. So
No
Mr.
problem
Hines,
if you
before
can send it over.
Okay, before you leave today, you need to go next door to the probation department and check in with them, okay? And then you'll be notified of the date and time of the sentencing hearing. Make sure that you stay in touch with your attorney, okay? All right, thank you, that's all for today.
Here's the back code.
750.81 A is an Adam.
Thank you.
People versus Timothy Hiddle, file number 244994. Record should reflect that Mr. Hiddle is present here in the courtroom today. If I can have counsel put your appearances on.
I just go back to people, Your Honor.
Al Travis on behalf of Mr. Hiddle, Your Honor.
This is the date and time set for sentencing in this matter. Mr. Hiddle, did you have a chance to go through the pre-sentence report and talk to your attorney about that?
Yes.
And Mr. Travis, are there any additions, deletions, or corrections to that report?
No, but maybe I think Mr. Ziegler may raise an issue, and then I have talked to Mr. Hiddle about that. So maybe I won't jump ahead of Mr. Ziegler.
Okay. Mr. Ziegler?
Your Honor, I'm not sure that it really matters that much, but on evaluation of plan, paragraph 6, it says that he has a 10-year gap just based on the information in the report. I don't believe that's accurate, but it doesn't really affect anything because this is a misdemeanor. I just wanted to object to that.
Okay, and I mean, from a factual standpoint, Mr. Travis, where do you come out on that?
Well, I understand where Mr. Ziegler's at. There's a 2008 conviction that indicates he got a year of probation, but it does not list a discharge date. So we're literally talking a matter of weeks, whether this overlaps or not. And speaking of Mr. Hiddle, obviously we haven't pulled all the records and even the report's kind of lacking on that. It does not list a discharge date. Mr. Hiddle believes he paid off his fines and costs and was discharged early because he'd actually moved up to Michigan at that point and left Ohio. So our position would be he did make the 10-year gap, but we do understand the report's lacking and don't have the information. And if he did do that whole year of probation, what Mr. Ziegler's saying is logically correct. We just don't think that happened.
So I guess what I'm gonna do then, Mr. Ziegler, is I'm gonna ask Ms. Wagner just to add a sentence that says that people contest whether or not there was a 10-year gap.
That's fine.
Okay. Any other corrections, Mr. Ziegler?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I agree with the recommendation contained in the PSI. Mr. Hiddle has a history of drug offenses and assaultive offenses. And in this case, he was willfully disobedient to simple commands from law enforcement to show himself when he was subject to an arrest warrant. I think a short term of jail is appropriate in this case to impress upon Mr. Hiddle that he needs to comply with the commands.
Mr. Travis?
Your Honor, Mr. Hiddle did do 7 days in jail on this. He pled guilty to this. He understands he shouldn't have done it. It was, where it cares to hear it, but it was an interesting situation watching the video. As it's noted, they believed he was in the camper. He is actually underneath the camper. It's maybe a distinction without a difference, but they kept telling him to get out of the camper. He was out of the camper. When they saw him and made eye contact with him, he, started to come out. There was a little bit of a scuffle, but it was very minor on the video. He didn't even fully roll over when they're saying he pulled away from him. He acknowledged that he didn't give him his hand as quickly as he should have and pled to that. But I guess I would say, Your Honor, as much as Mr. Hiddle does have a history, as much as he knows better, this was not a particularly egregious or escalated event on his part. It was not a lights and sirens. It was not a flee and elude. He just suspected the officer was looking for him and ducked under the camper. So he's here for a reason. He knows he's here for a reason. He pled, but he did do some jail time on this already, Your Honor. Thank you.
Mr. Hiddle, anything you wanted to say today?
Basically, there was a lot of misunderstanding on it. The reason that I was underneath the camper was I was working, trying to get it to, I was helping a buddy that was winterizing the vehicle or winterizing the camper. There was a hole in the bottom of it and I had my earbuds in. Really, I wasn't like paying attention to my surroundings. I had my head up inside of this hole trying to figure out, how to get it secured where there was no more animals going in and out of it. As soon as I did notice that there was someone there, they pretty much is when they flashed the flashlight underneath and I came out as soon as they did. Wasn't trying to disobey them. Sorry that it did happen, the way it did. I definitely should have responded faster and been more aware of my surroundings.
Okay. I read through the report. It's a lot different than the way you're describing it to me. So based on what's in the report, I really don't believe that you were under that camper working on it. Doesn't make any sense compared to what's in the report. So you know better, if you got a bench warrant or some kind of warrant, the police are gonna catch up to you, right?
I had actually had no clue about the bench warrant or anything.
Okay. Right. Whatever. That trying to hide from the police or run from them is just not gonna work.
Correct.
Right? I mean, you're gonna get caught. You're 44 years old. You've been around enough to know that that's the way it's gonna end. So in the future, just don't do that. It's a waste of your time. Now you're here with another charge. Done 7 days in jail. I don't think this warrants additional jail time, but you're gonna pay a bunch of fines and costs. Where if you just turn yourself in, you got to deal with that part of it, but you don't get all this extra on top of it. Right. So next time, just do what you're supposed to do, save yourself the hassle and the police and everybody else. But if you don't care about that, at least save yourself the hassle and the money. The court is going to impose 7 days in the Kalkaska County Jail with credit for 7 days served. Crime victims assessment of $75, court costs of $325, attorney fees of $350, and a $53 state cost. You do have the ability to seek an appeal of this sentence. If you wanted to do that, you would need to file that within the next 21 days. If you have more questions about that, Mr. Trevis could help explain that process to you. Otherwise, when you leave court today, you need to go next door to the clerk's office to make arrangements to pay those fines and costs. Okay. Thank you.
Your Honor.
Is that your last case, Mr. Travis?
I believe so. I was just glancing at the docket, but I think we've got everybody I've got highlighted, we've seen.
Okay. All right. People versus Jacob Garcia. So it's file number 255081. Mr. White, are you able to hear me okay?
Yes, Your Honor. I got you loud and clear.
All right, we just called People versus Garcia. Mr. Garcia is present here in the courtroom today. This is the date, time set, excuse me, for sentencing in this matter. Mr. Garcia, did you have an adequate opportunity to go through the pre-sentence report and talk to your attorney about that? All right. Mr. White, are there any additions, deletions, or corrections to that report?
Yeah, for the record, Your Honor, Nathan White appearing on behalf of the defendant. We've had an opportunity to review the pre-sentence investigation report. We have no additions, corrections, deletions to that report.
All right. Are there any challenges to the scoring of the guidelines?
The guidelines seem consistent, Your Honor.
That's a no?
Yeah, yeah, I'm sorry. Thank you, Your Honor. Yeah, that is a no.
Just want to make sure the record's clear, that's all. Okay.
Yes,
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I think this is the kind of case that HIDA was designed for. Mr. Garcia is a young man. He's made an incredibly poor and dangerous decision to run from the police. His decision-making placed himself, law enforcement, and the general public at risk of serious harm or death. However, it seems to me that Mr. Garcia is taking the matter seriously, and he is unlikely to reoffend. I disagree with the PSI author that upfront jail is warranted in this case. I believe that Mr. Garcia has the understanding, the remorse, and the family support to do well on probation, and he does not need some upfront jail to impress upon him the seriousness of what he's done. If I'm mistaken about that, and if he violates probation, he certainly will have significant consequences, including potential jail at that time and felony on his record. I think that this is sufficient punishment at this time. So I would simply ask the court to place the defendant on HIDA probation and give him an opportunity to demonstrate those things to the court.
Thank you. Mr. White, anything on behalf of your client today?
Yes, Your Honor. I'd agree with the state with respect to the position on HIDA probation. I took this case pro bono, Your Honor. I know Mr. Garcia. He attended high school with my son. He recently lost his father. And when he first came to me about this incident, I had some serious concerns about what some of the underlying issues were, maybe some things that he was going through. I talked to him and his mother regarding the issue, the situation. We got him into counseling. We've had many conversations about the seriousness of this offense, and I do agree with the state that this is the sort of situation where HIDA is appropriate. He made a horrible mistake, but in the meantime, what he has done is he's attended counseling on a regular basis to work through some of the underlying issues that may have precipitated for the poor decision making in this process. In addition, he's continuing to attend school. He's going to finish his schooling. He has a job that he starts next week to begin working in the field that ultimately he wants to be an electrician, and he has a job that's moving him forward in that direction. I've been in communication with him, not just as an attorney, but also a family friend and somebody who's concerned about what their family dynamics going through. His family's from Romania. They came to this country. They worked hard, but his father wasn't just a father. He was a very close friend and a confidant for him. So that loss was immeasurable. And we've been working together with counselors and myself, encouraging the family to readjust to the new dynamic, to encourage him to move forward with his life, to do the things that his dad would have wanted him to do. I'm happy with the progress he's making. I believe that given height of probation, that he will excel and be successful at that. And again, to echo the sentiment of the state, I think this is a good case for height of probation.
Thank you. Mr. Garcia, anything you wanted to say today?
Yes, I would like to apologize to you, to the community, and to the police officers for what I've done on July 5th. That's not how my mom raised me. I take full action and responsibility. I lost my dad this year, my best friend, and I made a big mistake. I knew what I did was wrong. I'm here today to tell you that I will never make that mistake again. I'm truly sorry for that.
All right. Well, I read through the report, and so I'm familiar with your actions in this case of bringing you before the court, and I'm familiar with kind of your background and circumstances based on all the information in that report. I've listened very carefully to what the lawyers have had to say and yourself. I get the sense that you are taking this seriously. You're not just up here saying this because you're in trouble.
Yes, sir.
I think that's important. I think what you did in this case, as you know, very, very dangerous. I mean, it is really just by, whether you want to call it luck or the grace of God or whatever, that somebody wasn't pulling out into one of those intersections as you were barreling through there. That route that you took, I know that route really well. We've had some terrible accidents along that route. We had an accident probably 10 years ago now where some members of a golf team were hit by somebody running through an intersection along that same route and killed high school kids. And I immediately thought of that as I was reading through this, because it was a terrible and shocking event for the entire community that people are still affected by 10 years later in Grayling. So you need to understand that what you did was not just a momentary lapse in judgment. You were making a life and death decision on that night. And we're all thankful that it didn't result in something more serious than it did to yourself or to somebody else. It sounds like you're working on maybe some of the underlying reasons that led you to do what you did. I think some of it is just, as a young person, sometimes we just don't know. I say we, I'm not a young person anymore, but you don't know how to deal with certain situations the right way. And sometimes that takes some help and some guidance and some maturity. And I feel like based on what I've read and heard that you've got that kind of help that's going to lead you in the right direction and help you cope with those underlying things to prevent you from doing this kind of thing again. And I think it's appropriate to give you that opportunity because you do have those supports. I think that the Homes Youthful Trainee Act, as the lawyers have said, was designed for this exact situation. So I think all of that's appropriate. I'm not going to impose any upfront jail time. I agree with the prosecutor, although I think the recommendation is perfectly reasonable as well. Give you 30 days to see what it's like in a jail to help you decide that that's not where you want to end up. I think that's reasonable, but I also think it's reasonable to give you the opportunity to avoid that. So I'm going to impose jail time, but I'm going to hold it in abeyance. If you successfully complete your probation, then you would never have to serve that time. However, if you violate your probation in any way, I can impose any or all of that time upfront immediately, no hearings, no nothing. You just go right to the jail. I hope that's not the way things go. And I think there's, again, some assurances here that you're going to follow through and successfully complete your probation. but that should be an added motivation to you to follow every single letter of your probation. Because even a minor slip up could land you in the jail. So the court is going to send you to probation for a period of 1 year pursuant to the Homes Youthful Trainee Act. The court's going to adopt as the conditions of your probation all the terms and conditions listed in this report. So when you meet with your probation agent, it's important that you go through that you get any questions that you have answered so that you fully understand your obligations. The court is going to sentence you to 90 days in the Kalkaska County Jail with credit for 1 day served. The court is going to hold that time in abeyance to be used at the discretion of the court. A crime victim's assessment of $130, court costs of $325, and a $68 state cost, in addition to a supervision fee while you're on probation of $30 per month. Because this is pursuant to HIDA, there are no appellate rights at this time. Ms. Wagner, what does Mr. Garcia need to do in terms of his probation as a next step?
If he can come over to my office and I'll go over some things with him. Thank you.
Okay, so Mr. Garcia, when you leave court today, go to the probation office next door. Mr. Ziegler, anything further on this file today?
No, Your Honor.
Mr. White?
Nothing further, Your Honor. Thank you very much.
Okay, good luck to you going forward, Mr. Garcia.
Thank you.
Okay, we'll go on the record in People versus William Isaacson. This is file number 255084. And Mr. Haney, you're appearing on behalf of Mr. Isaacson, is that correct?
That is correct, Your Honor. Thank you, and thank you for the courtesy of Zoom today. And Mr. Isaacson is also present via Zoom.
All right, I cannot see Mr. Isaacson. So Mr. Isaacson.
You hear me? All right.
I can hear you. What's wrong with your camera?
I'm looking right now. Says it's on.
There may be a slide at the top of your screen that you have to click over. It's a mechanical.
Let me see. No, not on my computer. There isn't. I see you guys, but it says my camera's on.
All right, let's go. All right, that's fine. Let's go forward with the hearing. This is set today for a status conference. Mr. Haney, can you tell me the status of this file from the defense side right now?
Yes, Your Honor. We have received the discovery from prior counsel and also from Mr. Ziegler. We've had some issues opening up body camera footage. I'm not too sure what the problem is. I don't believe it's any fault of Mr. Ziegler's. The format of whatever receiving it in is not or hasn't been able to be opened. We are obtaining the body cam footage directly from the Michigan State Police that I hope will rectify that problem. Other than that, we should be ready to choose a trial date with the court's scheduling.
All right, so Mr. Haney, are you anticipating that this is going to proceed to trial, or are you still negotiating with the prosecutor for a plea agreement?
Your Honor, I anticipate this matter will be a tried case. I believe we'll go to trial.
Okay, all right. Mr. Ziegler, anything that you wanted to add in terms of the status with regard to what Mr. Haney had to say?
No, Your Honor, I think that's accurate. The offer was made to prior counsel prior to the prelim. It's not likely to change, and Mr. Haney knows what that offer is. I think we just had some issue with the discovery, but if the court is willing to give us a date, the victims are present both by Zoom, and there's a member of the victim's family here in the courtroom, and they are very anxious to see a resolution to this matter one way or another. So I would just ask that if the defense is intent on proceeding to trial, if the court would just give us a trial date with a final cutoff.
All right, Mr. Ziegler, how much time do the people need to be prepared for trial in this case?
Your Honor, I would ask for at least 60 days, probably more like 90 days, just to make sure there's no further issues with the discovery. And then Mr. Haney and I are on the same page in terms of what we have. The discovery is also quite voluminous. I think it's about 40 or 50 gigabytes of video we need to work through.
Okay, and how many days of trial do you think we'll need?
I would say 2, Your Honor.
Okay. Mr. Haney, how much time do you need to be prepared for trial in this case?
Yeah, I would agree that perhaps 90 days would be appropriate, maybe 120 at the outside. There's a lot of discovery. I would believe the trial would probably be more than 2 days. I would think it's closer to 3 to 4 days, given that we'll have to pick a jury and instruct that jury. I would anticipate a 3 to 4 day trial. But I would ask that we have at least 90 to 120 days for preparation.
Okay. I mean, that's pretty much on your time frame, right, Mr. Ziegler?
Yes, Your Honor.
Okay. All right, I'm going to set it for a 3-day jury trial at 90 to 120 days out. The court will set this, Mr. Haney, it's my practice to set for a final status conference on my full motion day immediately preceding the trial date. And that is a motion cutoff, so both sides are free to file any pretrial motions that are needed at any time, but they must be filed and heard no later than the date of that final status conference. That is also a plea cutoff, so to the extent that there are any further plea discussions, that would be the last date to enter into a plea agreement. And then, Mr. Haney, to the extent you have any questions about trial procedure and so forth, those can all be addressed at that final status conference. But otherwise, the court won't schedule any other dates other than that final conference and the trial. Mr. Ziegler, are there any other dates that you'd like to request here today?
Not at this time, Your Honor.
Mr. Haney, are there any other scheduling dates you'd like to request?
No, thank you, Your Honor.
Okay, so the court will send out a scheduling order reflecting what we've discussed here today. The court will also send out notice of the date and time of that final status conference, as well as the trial dates. And Mr. Ziegler, anything else for today?
No, Your Honor.
Mr. Haney, anything further for today?
None on behalf of the defense, Your Honor. Thank you.
Okay, thank you. That's all for today. All parties on this file are free to disconnect at this time.
Thank you, Your Honor. Have a good day.
Thank you. Is Mr. Patrick present? Darnell Patrick? Okay, Mr. Patrick, you want to come up to the podium, please? Mr. Seeger, are you able to hear me okay?
I am, Your Honor.
Okay. All right, and we have, the record should reflect, we have Mr. Patrick present in the courtroom. This is People versus Patrick, file number 2449881. I have this set as a probation violation hearing today. Mr. Seeger, can you tell me how we're going to proceed?
Your Honor, just in speaking with the Department of Corrections, it's my understanding that they would not have an objection to an adjournment, given that the matter is based on a pending matter in another county.
Ms. Wagner?
Yes, that's correct, Your Honor. I think he next has court. I was just looking in case notes. In Antrim County, they're still pending, and I think he's coming up for next week sometime, or 2 weeks from now, for another court matter. So I would just ask this be adjourned pending the resolution of the other case.
Okay. Is that, Mr. Patrick, is that you have court dates in Antrim County coming up? Is that correct?
Yes.
Okay. All right. So I'm going to set this out 90 days. If the parties need to get it on for hearing sooner than that, we can definitely do that, but that'll give us adequate time for those other matters to get resolved. So, Mr. Patrick, it's just important that between now and then that you stay in touch with your attorney, with Mr. Seeger. And we'll send you notice of the date and time of that next hearing. Do you have any questions at all? No. Okay. Ms. Wagner, is there anything else we need to address from your side today?
None, Your Honor. Thank you.
Mr. Seeger?
No, sir.
Okay. All right. Thank you, Mr. Patrick. That's all for today. People versus May, file number 234826. Record should reflect Mr. May is present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler, again.
Scott Isles on behalf of Thomas May.
Mr. Isles, can you tell me the status of where we're at here today?
Your Honor, Mr. May has successfully completed sobriety court. In fact, he was the last person to do so before they shut it down. So we're here, I would assume, to go forward with the sentencing. And because he's successful, I believe we're dropping this down to a second. It's been an interesting case procedurally, Your Honor.
Yeah, so it has.
You know, in fact, if I could even address that, I got called on a Sunday afternoon by Mr. May saying he'd like to retain me. He'd already pled guilty, and sentencing was that morning, the next morning. I came in here and I talked to you about the fact that his attorney was a real estate attorney, and there were certain things that had not even been explored that should have been, including sobriety court. And I asked you to give us a chance to look into it, and you did. You didn't have to do that. Many judges I know would have said, no, we're here for sentencing today. He's already read his PSI. We're going forward. So you gave me that opportunity to adjourn it and look into that. Then I had a chance to talk to Mr. Ziegler and convinced him that, you know, given my client's horrific, chaotic upbringing and issues with alcohol, this was really more of an alcohol case than it was a violence case. And he and the sobriety court allowed Mr. May to join that. Mr. May had no backsliding, did not have any problems ever testing positive to the entire thing. And there were a lot of other obstacles that occurred during that time. He has leukemia, and he was diagnosed with a couple of other cancers during the process that he had to fight with. He had a problem with his 14-year-old daughter deciding that she wanted to go live with mom, and there was a big fight, and there was a whole thing between this county and down in Lansing where that case was being held. So there were a lot of things that went on that could have caused him to backslide. You know, there's some kudos that go to my client for the fact that he showed perseverance and determination to get through that program. I will tell you, he called me about 2 weeks ago to tell me how much better his life was since he's quit drinking, even to the point of when he was drinking, when he'd wake up in the morning, sometimes he'd wake up angry, and he doesn't do any of that anymore. So this is a real success story. It's not just his, it's also yours and Mr. Ziegler's for giving him the opportunity to prove himself.
All right, thank you. Mr. Ziegler, anything you wanted to say today?
Your Honor, it's been a bit of a rocky road for Mr. May. I think you would attest to that as well. We had a lot of issues with him in the program, but none of those issues were related to his sobriety and his dedication to the program. He performed admirably everything that the case manager asked of him. He did. It saddens me to see him go because, as Mr. Isles said, he is the last one out of our program, at least for now. But he is fully deserving of the benefit of successfully completing sobriety court. And I would ask the court to give him the benefit of the OWS second to reduce charge.
All right, thank you. Mr. May, was there anything that you wanted to say today?
Oh, there's so much I'd like to say. Like I lost 1,000 pounds.
So, here we go. I'm as guilty as they come. When I came in here, I was dead guilty and you should have sent me to prison. Been done with it, period. And I've been sober 30 months now. And your decision probably saved my life because I went through some serious cancer treatment in the months. And I don't know why that blessing was given to me. I don't know what made you make that choice. I don't know what made Mr. Ziegler make that choice. I know that my life has been irreparably changed for the better. And I don't have the words to even express the gratitude that I feel towards Scott Isles, Judge Boudet, the Sobriety Court ladies that helped me continuously, Mr. Ziegler for, sticking his neck out on a guy that didn't even deserve the chance, and you doing things that are completely out of the ordinary in the situation, all led me to this point in my life, which is the best point of my life ever. And I just want to thank you guys. Just want to, from the bottom of my heart, I want to tell you that without the opportunities that you and Mr. Ziegler gave me, I would be full of resentment because of prison. I'd be a hateful person. I would not have came out the way that I feel today about life. I don't have resentments. I'm happy that I got my drunk driving because this is the result of it. Just the differences that were made because of the decisions that you guys, I hope you catch my understanding. I'm not a great orator, but man, it's it's a miracle, really. It's the definition of a miracle.
Well, I think you're a good orator. I think you did a great job there. I think you're very articulate, and I think you express that really well. And I certainly can see where you're coming from. And I'm grateful that you're appreciative of the opportunity, but we can give opportunities. It takes you to put in the hard work and to do all the things that you've done over this period of time to change and to really make an investment in yourself. And you should be really proud of that. And I hope that you are. I hope you recognize all the work that you've done. It's not an easy program to go through, as you know. The people that are successful in it are people that want to make a change in their life because they want to live a better life, not because the court's making them do it. And it's clear that that's what you did. You took that program to heart. You've incorporated those things into your life and you're moving on and going to be successful and live a better life. That's more than what we could ask for. And I know that we're all happy about that. And when I look at it from the community's perspective, we're all better off having you in the community now than we would have been had it gone a different way. And so you've benefited through your work, not only yourself, but you're helping improve our entire community. And I appreciate that.
I appreciate you, sir.
And man, well done. I know it's been a struggle. I know about your health problems. Every time I see your name, I wonder how you're doing, because there's times when I've seen you where you didn't look good because of what was going on with your health. You look good today. I hope your health is stable and stays that way. And best of luck to you going forward. Congratulations.
Thank you so much.
Yeah.
Mertz.
Thank you. And what a great way to end a tough morning docket with some good news. So thank you for doing that. Appreciate it.
Thank you, Your Honor.
That's all we have for now, and we'll be back on the record at 1:30.
Thank you, Your Honor.